Welcome to Business Law 101. We've got a special update session for you on a hot issue in the news, and that is the interesting case of Jeffrey Epstein and his alleged procurer of young ladies, Ghislaine Maxwell. And it's been pretty interesting. The case has been rolling for quite a while. As most know, Jeffrey Epstein allegedly committed suicide after someone had turned off the observation videos in his jail cell, and guards that were supposedly checking on him hourly magically didn't check on him. In any event, the show came down to Miss Maxwell, and she was tried on 6 counts of basically prostitution and abusing underage women and so forth. And she was convicted on 5 out of 6 counts. New chapter, and the subject of business law today, which is the terminology of law. And one of the interesting things that happens is America is a very litigious society. And when things don't go our way, we usually run to the courthouse and file additional post-trial motions and also file appeals. This is the prosecution, which again has won, has gone to the judge and said, you know what, judge, we might need to take another look at this case because one of the jurors did not disclose the fact that he had been abused as sexually abused as a child. And this is something that was included in the pretrial questionnaire for jury selection. The term for jury selection is called voir dire. It is the questioning of jurors. Interestingly, the defense in this case didn't ask this particular juror any questions. They just said, relied on his questionnaire, and apparently he did not indicate that he had been previously sexually abused when he was a minor. And apparently during jury negotiations, things were not going well and they were not moving towards a resolution. And this gentleman made a big pitch for what he had been through in his childhood. And that apparently swayed some of the jurors to reach the 5 out of 6 guilty conclusion. Now, I'm not sure of the exact motion that's being involved here. There's a couple. One of them that could be used is a motion for new trial. We attorneys call that MNT. And it is something that happens if you feel that there was something really wrong with the case. And again, that's usually brought by the losing side, which would be the defendants here. Now, don't get me wrong, the defendants, as soon as the prosecution jumped in and said to the judge, hey, there might be something wrong, the defendants are all about that. They could also be arguing for a JNOV. And we still have a little bit of Latin left in the legal system, and that stands for judgment notwithstanding the verdict. And in Latin, that's judgment non obstante verdicto, JNOV. So I'm not sure which tool they're using in this particular case, but it's going to be very interesting to see what happens. So again, pay attention to terminology in the law, and this is going to be a continuing news case that will help update your business law knowledge. This is Dr. David D. Schein. Thanks for joining us.